At exactly 10:42 p.m. on a cold Thursday night in November, on the quiet, tree-lined streets of Harwick, Virginia, a traffic stop that should have lasted 3 minutes became the most consequential 11 minutes in the history of the Harwick Police Department. The body camera footage, which the department tried to bury for 6 weeks, would eventually be viewed over 31 million times. It would be dissected by legal scholars, replayed on every major news network, read into the congressional record, and submitted as exhibit evidence in a federal civil rights complaint that reached the desk of the United States Supreme Court. But before any of that happened, there was just a man, a quiet, dignified man, sitting alone in his car on a dark street, hands flat on the dashboard, watching a flashlight approach his window. And in that moment, he made a choice that most people in his position never get to make. He chose to fight back, not with anger, not with fear, but with 31 years of federal law stored in his memory like a weapon he had been carrying his whole life, waiting for exactly this moment. Before we go any further, do me a favor. Drop a comment right now and tell me where you are watching from. And if you have not subscribed yet, hit that button, because this story is going to take you somewhere you are not expecting, and you do not want to miss a single second of what happens next. Judge Elijah Monroe was not your average 58-year-old driving home from work on a weeknight. While most men his age were thinking about retirement, Elijah Monroe was still in the middle of one of the most respected careers in the American federal judiciary. He had grown up in Roanoke, Virginia, the son of a public school janitor and a church choir director, in a household where education was treated like oxygen, something you could not survive without. His mother used to say that they could take everything from a black man in America except what he had memorized. So, Elijah memorized everything. He earned a full academic scholarship to Howard University, graduated at the top of his class, and went straight to Harvard Law School, where he made law review in his first year and graduated with honors. He clerked for 2 federal judges before joining the NAACP Legal Defense Fund, where he spent 8 years litigating some of the most significant voting rights and police misconduct cases in the South. He argued before the Supreme Court twice before he was 40 years old. He won both times. President Clinton appointed him to the United States District Court in 1997. President Obama elevated him to the Fourth Circuit Court of Appeals in 2011. In 31 years on the bench, he had written over 400 published opinions. Legal scholars had cited his Fourth Amendment rulings in textbooks used at Yale, Stanford, and Columbia. He had been offered a seat on the Supreme Court twice and declined both times because, as he told a reporter in 2019, he believed he could do more good from where he was. He was also a black man who had been followed in stores, watched in parking lots, and pulled over by police more times than he could count on both hands. He had never forgotten that no matter how many robes he wore, no matter how many courtrooms he commanded, there were places in this country where none of that mattered, not one single bit. On the evening of November 14th, Judge Monroe had presided over a late evidentiary hearing in a complex civil rights case involving the unlawful detention of 17 black men by a county sheriff's office in rural North Carolina. It had been an emotionally exhausting day. The testimony had been graphic. The pattern of abuse had been clear. He had stayed 2 hours after the hearing to review additional filings, eaten a sandwich alone at his desk, and finally left the courthouse just after 10:15. He was driving his own car that night, a dark blue Volvo, modest and unremarkable, exactly the kind of car a federal judge might drive when he wanted to be left alone with his thoughts. The streets of Harwick were quiet. The neighborhoods near the courthouse were old and well kept, lined with oak trees that arched over the road like cathedral ceilings. It was the kind of place where nothing ever happened this late at night. He was not speeding. He was not swerving. He was not on his phone. He had not run a single light. He was simply a tired man driving home, following every traffic law with the careful precision of someone who had spent 3 decades enforcing them. Then the blue and white lights of a Harwick police cruiser lit up his rearview mirror, and Judge Elijah Monroe felt something in his chest that no law degree and no lifetime of achievement ever fully takes away. That old, cold, familiar feeling. The one that black men in America learn before they learn to drive. His hands went to the dashboard before the officer even reached the window. Not because he was required to, because 31 years of reading police misconduct cases had taught him exactly what to do and exactly what not to do. He took a slow breath. He told himself to stay calm. And he reached over and made sure his own personal dash cam, mounted discreetly near the rearview mirror, was recording. The officer who approached that window was Brett Calloway, 44 years old, 17 years on the Harwick force, and a man whose personnel file, which would later become public record, contained 9 internal complaints over his career. 3 of those complaints involved allegations of racially biased policing. None of them had resulted in any formal disciplinary action. He had been promoted twice. He was considered, by his supervisors, a reliable and experienced officer. He had never, in 17 years, encountered anyone who pushed back. That was about to change in ways he could not begin to imagine. Calloway tapped the window with one knuckle. Judge Monroe lowered it. The first thing Calloway said, captured clearly on his own body camera, was not a greeting. It was not a statement of the violation. It was not the professional opening that every law enforcement training manual in the country requires. It was a question. He looked at the judge, looked at the car, looked at the neighborhood, and said, quote, "You got any warrants? Any drugs in this vehicle? Not hello. Not the reason for the stop. Not license and registration." His very first words were a fishing expedition aimed at a man he had decided was out of place before he had spoken a single word to him. Judge Monroe did not flinch. He asked, calmly and clearly, what the legal basis for the stop was. And Calloway, 17 years into a career that had never once required him to justify himself to a driver, said the quiet part out loud. He said, and I want you to hear this clearly, because the body camera caught every syllable he said. Quote, "You are in a neighborhood you do not belong in, pal. That is basis enough for me." In those 14 words, Brett Calloway had just handed a federal appellate judge, a man who had built his career on exactly this kind of statement, everything he needed. What happened next was not a confrontation in the way most people imagine confrontations. There was no shouting. There was no dramatic moment where the judge slammed his credentials on the dashboard. Judge Monroe did not raise his voice once in the entire 11 minutes that followed. What he did instead was something far more powerful. He talked. Slowly, precisely, with the measured calm of a man who had delivered oral arguments before 9 Supreme Court justices and never once lost his composure. He told Calloway his name. He told him his title. He told him what court he sat on. And then he told him, in plain and simple language, that what Calloway had just said, being in a neighborhood you do not belong in, had absolutely zero legal standing as grounds for a traffic stop under the 4th Amendment of the United States Constitution, under Terry versus Ohio, under Wren versus United States properly applied, and under the 4th Circuit's own precedent, 3 cases of which Judge Monroe himself had authored the majority opinion. Calloway's response to all of this was to tell Monroe to stop being difficult and get out of the car. And here is where the story turns. Because instead of complying, instead of diffusing the situation the way every black professional in America is quietly coached to do, smile, cooperate, survive the encounter, and fight it later, Judge Monroe made a different choice. He said clearly, for the camera, that he was not refusing to exit the vehicle, but that he was invoking his right to understand the lawful basis for the demand before complying, citing Pennsylvania versus Mims and Rodriguez versus United States. He said it the way a professor recites a formula: confident, unhurried, immovable. Calloway called for backup. For those of you watching right now, I need to ask you something. If you were sitting in that car, knowing what you know, knowing who you are, knowing that what is happening to you is wrong, would you have the courage to do what Judge Monroe did? Drop your answer in the comments. I genuinely want to know. When backup arrived, it was Officer Dana Price, 6 years on the force, body camera rolling. The 2 officers conferred briefly near the cruiser, while Judge Monroe sat still, hands visible, dash cam recording. Then, Calloway came back to the window with a different energy, harder, more certain of himself now that he had a witness in uniform. He told Monroe he was being detained for suspicious behavior and ordered him out of the vehicle a second time. Monroe asked what specific behavior. Calloway said he had been driving slowly and appeared to be casing the area. Monroe noted, calmly, that there was no ordinance against driving slowly on a public street, and that the word appeared in Calloway's own statement revealed that it was subjective observation, not articulable fact, which was the legal standard required under Terry. Then, Calloway opened the car door. He physically opened the driver's door of a federal judge's car, reached in, and told Monroe he was placing him in investigative detention. He put his hand on Monroe's arm, and Judge Monroe, who had not raised his voice once, had not made a single threatening movement, had answered every question with precision and patience, looked at Calloway's hand on his arm, looked up at him, and said, in a voice so quiet the body camera almost did not catch it, "This is going to be in a Supreme Court filing. I need you to understand that." Calloway cuffed him anyway, walked him to the back of the cruiser in handcuffs. A sitting federal judge, on a public street, for driving while black. Officer Price stood to the side. The body camera caught her face. She looked uncomfortable. She said nothing. She did nothing. The entire detention lasted 22 additional minutes before a supervisor arrived, took one look at the situation, recognized the judge by name, and had Monroe uncuffed immediately. By then, the dash cam in the Volvo had recorded everything. Every word, every second. Now here is where the story shifts completely. Most people who experience what Judge Monroe experienced that night go home shaken. They talk to a lawyer. They file a complaint that disappears into a department investigation that takes 18 months and produces a 2-paragraph letter saying the officer acted within policy. Most people lose, not because they are wrong, but because the system that is supposed to investigate itself almost never turns on itself. But Judge Monroe was not most people, and the complaint he filed the following morning was not a standard civilian complaint form. It was a 47-page formal legal document filed simultaneously with the Harwick Police Department, the Virginia State Police, the Department of Justice Civil Rights Division, and the Chief Justice's Office of the Fourth Circuit Court of Appeals. It included the full dashcam footage from his vehicle, a time-stamped transcript, citations to 31 separate legal violations, a breakdown of Calloway's prior complaint history obtained through public records, and a section titled Pattern and Practice Evidence that was 11 pages long on its own. His law clerk, who helped him format it, later told a reporter that she had stayed in the office until 4 in the morning because the judge was not going home until it was filed. She said he was the calmest she had ever seen him, like he had been waiting his whole career to write this particular document. The Harwick Police Department received the complaint on a Friday morning. By Monday afternoon, Brett Calloway had been placed on administrative leave. That was not normal. Usually these processes take months, but the complaint was so detailed, the footage so clear, and the subject so unimpeachable that the department had no room to maneuver. The walls closed in almost immediately. The internal investigation was assigned to Captain Leonard Voss, a 20-year veteran who had a reputation for fairness that was unusual in that department. Voss pulled every piece of footage. He watched the body cam recordings from Calloway and Price. He watched the dash cam footage from Monroe's vehicle 3 separate times. On the third viewing, he brought in the department's legal counsel to watch it with him. The footage confirmed everything in the complaint, every single allegation. Calloway had failed to state the reason for the stop. He had made a racially suggestive statement in the first 60 seconds. He had cited a traffic violation, slow driving, that was not a violation under Virginia law. He had physically initiated contact and placed a citizen in restraints without meeting the legal threshold for investigative detention. He had failed to identify himself by name and badge number when requested, which was required by department policy. And he had done all of this to a federal judge, on camera, with a second officer present who failed to intervene. But then Captain Voss found something else, something that nobody had expected, something that took what was already a serious case and turned it into something significantly more alarming. When Voss pulled Calloway's stop records for the previous 2 years, he found a pattern that stopped him cold. Of the 340 traffic stops Calloway had initiated in Harwick over 24 months, 279 of them, that is, 82%, involved black drivers. In a city where black residents made up 31% of the population, the stops were concentrated in 3 specific neighborhoods that Calloway had designated in his own private notes found on a department-issued tablet as, quote, problem areas. Those 3 neighborhoods were the city's 3 predominantly black residential districts. Calloway had not stumbled into the habit of racially biased policing. He had systematized it. He had a routine. He had zones. He had been doing this for years, to hundreds of people, and not a single supervisor had ever looked at his stop data carefully enough to notice. Captain Voss sat with that information for a long time. Then he picked up the phone and called the chief. Do you think the department would have ever found this pattern if Judge Monroe had not filed that complaint? I mean, really think about that. Leave your answer in the comments. The story stopped being a local matter the moment the Department of Justice Civil Rights Division in Washington received their copy of the complaint. Within 3 weeks, federal investigators from the DOJ arrived in Harwick. They were not there just for Calloway. They were there for the whole department. Judge Monroe's filing had triggered what is known as a pattern or practice investigation, the most serious type of federal civil rights inquiry that can be directed at a law enforcement agency. And once that process begins, it does not stop until everything is examined. The investigation lasted 5 months. Federal investigators reviewed nearly 4,000 stops. They interviewed 61 officers, 22 supervisors, and over 100 community members. They examined training materials, disciplinary records, and the unofficial culture of the department as described by officers who had grown tired of staying quiet. What they found was that Calloway was not an anomaly. He was the most extreme example of a practice that had been tolerated, even informally encouraged, for over a decade. The department had a documented history of discouraging officers from writing up racial bias complaints against their colleagues. 2 supervisors had actively suppressed complaints. One of them was still in a command position. The DOJ released its findings in a 73-page report. It was brutal. It concluded that the Harwick Police Department had engaged in a pattern of racially discriminatory traffic enforcement that violated the 4th and 14th Amendments of the Constitution. It named Calloway specifically. It named both supervisors. It outlined a mandatory reform consent decree that the department was required to implement under federal oversight for a minimum of 5 years. Brett Calloway resigned 4 days before the report was made public. He did not get to retire with his pension fully intact. He did not get a send-off. He did not get the dignified exit that 17 years might otherwise have earned him. He cleaned out his locker on a Tuesday morning when nobody else was in the building and left. His 17-year career ended because of an 11-minute encounter with a man he had decided did not belong in a neighborhood. A man who had spent 3 decades making sure that people like Brett Calloway could be held accountable. Officer Dana Price, the backup officer who stood there and said nothing, was not terminated, but she was placed on a remedial training program, received a formal reprimand in her personnel file, and was passed over for a promotion she had been expecting. She would later give an interview to a local paper in which she said she had known something was wrong that night, but did not know how to stop it. She said it was the biggest regret of her career. Many people who watched the footage did not find that sufficient. That debate continues. When the body cam footage was released as part of the public records request that followed the DOJ report, it did not leak slowly. It detonated. Within 48 hours, it had been picked up by every major national news outlet. Legal commentators spent hours breaking it down frame by frame. A retired federal judge appeared on CNN and said, voice cracking, that watching a colleague in handcuffs on a public street for no lawful reason was one of the most difficult things he had ever witnessed in 50 years of legal practice. Civil rights organizations called it a defining moment. Social media was simultaneously outraged and galvanized. The hashtag Justice Monroe trended for 11 consecutive days. Law schools across the country began incorporating the footage into their constitutional law curriculum. One professor at Georgetown, Monroe's own alma mater, told her students that the footage was the single most effective teaching tool for the Fourth Amendment she had encountered in 30 years of teaching. Some people online criticized Monroe for escalating the situation. They said he should have simply complied, shown his credentials, and resolved it quietly. They said his refusal to immediately get out of the car put him at risk. And to those critics, here is what the footage actually shows. Monroe did not escalate. He de-escalated, repeatedly, with extraordinary precision, while Calloway escalated at every single turn. The only thing Monroe refused to do was pretend that what was happening to him was legal. And that is not escalation, that is dignity. Here is a question for you before we get to the final chapter of this story. Do you think what Judge Monroe did took more courage because of who he was, or in spite of it? Think about that carefully, and let me know in the comments. As of today, Judge Elijah Monroe is still on the bench. He did not retire. He did not request a transfer. He did not quietly disappear from public life the way the department might have hoped he would. He went back to work the following Monday morning, presided over his docket, and has not given a single media interview about the incident. His only public statement was a 3-paragraph written release that ended with these words, quote, "I did not file this complaint because of who I am. I filed it because of who they were, and because somewhere in this country tonight, someone without my credentials, without my resources, without my platform, is in the back of a police car for the exact same reason I was. This one was for them." End quote. He has since authored 2 additional Fourth Amendment opinions that directly address pretextual traffic stops and the standard of articulable reasonable suspicion. Both opinions have already been cited by courts in 7 other circuits. The legal community widely expects at least one of them to reach the Supreme Court within the next 2 years. So what do we take from all of this? What does the story of Elijah Monroe actually teach us? The first lesson is that documentation is everything. Judge Monroe's dashcam was the foundation of everything that followed. Without that footage, this is a complaint that goes nowhere. With it, it becomes a federal investigation. If you are a driver in this country, a dashcam is not optional. It is essential. The second lesson is that knowing your rights is not enough. You have to be willing to use them in the moment when it is hardest, when there are handcuffs in the equation, when the power imbalance is right in front of your face. That takes a specific kind of courage that is not taught in any classroom. The third lesson is about patterns. Calloway was not the whole problem. He was the visible tip of a system that had been running quietly for years. One complaint from one extraordinary man cracked it open. Imagine what would happen if more people had the tools and the confidence to file complaints that were thorough, documented, and legally precise. The fourth lesson is about institutions. The Harwick Police Department did not fix itself. It was forced by a complaint, by footage, by federal oversight. Institutions rarely reform from the inside. They reform when the cost of not reforming becomes greater than the cost of changing. Judge Monroe made that cost undeniable. And the fifth lesson, maybe the most important one, is this. The badge does not make someone right. The robe does not make someone safe. And the law, as written, belongs to everyone, not just to the people who are allowed to feel comfortable invoking it. One person, one traffic stop, 11 minutes, and a 31-year career wielded with the precision of a surgical instrument. That is the power of preparation. That is the importance of refusing to be silent when silence feels like the safer option. That is what happens when someone who has spent their entire life studying injustice finally comes face to face with it in a personal way and decides that this time it is not going to slide. Final question for you. What is one thing you learned from this story that you did not know before watching it? Drop it in the comments below. I read every single one. And if this story moved you, if it made you think, if it made you want to know more, subscribe right now. Because we tell these stories every week, and every single one of them matters. This story is not just about Judge Monroe and Officer Calloway. It is about every black driver who has ever seen those blue lights come on and felt that cold, familiar feeling settle in their chest. It is about every complaint that was filed and ignored. It is about every officer who stood by and said nothing. It is about every system that ran on silence until someone finally made enough noise that the silence was no longer possible. Elijah Monroe's legacy is not just the DOJ report. It is not just the consent decree. It is not just Calloway's resignation or the policy reforms or the law review articles that will cite his opinions for the next 50 years. His legacy is the reminder, sharp and undeniable, that knowledge used with courage, at the right moment, in the right way, can dismantle in 11 minutes what arrogance and impunity have been building for years. This is the story of how a racist cop detained a black civil rights judge, and how a Supreme Court investigation ended his career. But more than that, it is a story about what justice actually looks like when someone refuses to let it be deferred.